Good morning, friends. Today we are going to talk about a very important topic, that is the preamble of the Indian Constitution. What is the importance of the preamble? One may ask it, whether it is legally binding, what is its validity, whether it can play any restrictive role upon the amending power of the government, parliament, how the preamble has been drafted, or the history of making the preamble, how to remember the parts of the preamble easily. All these things we can discuss in this particular program is concerned. First, let us go through what is the preamble, why we should study it. The meaning of the term preamble, it is etymologically speaking, it is a Latin origin. Pre plus amblia, preamble. That's how the word has come. That means you can amplify anything much prior to that, before you go into the reality, the real picture of it. So that is the preamble. Okay. So this is, people may believe that something, people may call it as a mere introductory note. It's not mere introductory note. In fact, it lays down the objects, it guides everything, the entire document. It is something like by going through the preamble of the Constitution, you can have a fair idea about the entire Constitution. That's very, very important. Something like when you are reading the executive summary, you will have an idea what the thesis wants to convey, something like that. Now, having said about the meaning of the term preamble, let us go through the content of the preamble. Preamble, you can divide the content of the preamble into 4 ways. First, it talks about the legitimacy of making the Constitution, including the preamble. Who has empowered the Constituent Assembly to make the Constitution, to draft the Constitution? Under what authority they have drafted the Constitution? Is it by virtue of Indian Independence Act? Is it, or beyond that? The answer is simple. The Constituent Assembly has not been set up by the Indian Independence Act. Then how it has come? Of course, history will tell you there are various commissions and all other things, but it has not come from the sky. It has certain connection with the people of India. That's very important. Though the connection may be remote, connection may be indirect, not direct. But however, they are the representatives of the people. The people have authorized them, the members of the Constituent Assembly, to draft the Constitution. So they are deriving the authority from the people of India. That's very, very important. Okay. So you have spoken about the authority of making the Constitution. Who has conferred the authority? The people of India. We the people have conferred this power to make the Constitution by the Constituent Assembly. That's very important. Next, what is this Constitution is talking about? What sort of government you wanted to establish? That's very important. The nature of the Indian state itself, what you call Bharat, India is an union of states. What is the nature of your state? Is it a mere federalism? Is it whether it has any religion? The answer is no, it's a secular state. Whether it's an autocratic state? No, the answer is democratic state. What sort of form of government you wanted to have? Is it monarchy? No, the answer is republic. And what sort of form of government you have? Presidential? No, the form of government is parliamentary. So all these things have been explained in the very first 5 terms: sovereign, social, secular, democratic, and republic. All these key terminologies talking about the nature of the state, nature of the government, the nature of the political, constitutional, legal, administrative, and other establishment of this particular country is concerned. Okay. By you have established all these things, what are you going to do then? You have a mandate. Who has the mandate? The Constituent Assembly, the government has a mandate. The state under Article 12 has a mandate to fulfill certain goals. What are the goals? That also been prescribed by the very preamble itself. Justice, liberty, equality, fraternity, dignity of the individuals, and unity, integrity, all these things. Now, so What sort of goals? Which we have already told you. The last part, it talks about the timing of the adoption of the constitution, the place of adoption of the how and when, where we have adopted the constitution. This is how you may link with the social contract theory. When we have adopted the constitution, on the 26th November 1949. Okay, by whom? By the people, through whom? Through the Constituent Assembly. That is the modus operandi. So we ourselves, that's the word. We ourselves give it to the Constitution and adopt this 26th day of November 1949 in the Constituent Assembly. That is the phrase they have used. So we have broadly classified the parts of the preamble into four. That is the legitimacy part, the authority part, the nature of the Indian entity, then the objectives to be fulfilled, then the timing, that is the history. Okay, all these things okay. Then how the preamble has been drafted, how the preamble has been made. People may simply say, when you prepare for your UPSC exam, it is nothing but it is a objective resolution class. No, the answer is not that. Of course, more than 70% is from objective resolution class. You know the origin of the objective resolution class. It is not merely moved in the Constituent Assembly itself. It dates back to the Lahore Conference in 1929, when the Indian National Congress has declared Purna Swaraj. And Purna Swaraj, who has precursored, Tilagar, Balagangadhar Tilagar has said, Swaraj is my birthright. And you also remember there is a Nehruvian committee report relating to the fundamental rights made in 1928. All these things have played a vital role in shaping the objective resolution class. Please remember, preamble was not the first item drafted by the Constitution. It was the last item drafted by the Constitution, or the last aspect drafted by the Constituent Assembly. Please remember that. So people may believe the preamble was the first article or first provision of the Constitution which has been drafted by the Constituent Assembly. No, it was moved in the Constituent Assembly, but later on Ambedkar has written a letter to the Constituent Assembly chairman to defer this, and he added certain things. The credit goes to Ambedkar for adding two important terminology which was not there in the objective resolution class. What are the two important terms? One, fraternity. This is missing in the objective resolution class. Because Ambedkar, he is the champion of the leader of depressed or oppressed caste, whatever we may call it. But he is the champion of the human rights movement, particularly he is the protector of Dalits, and later on, of course, he has voiced for the women emancipation also, women's freedom also. Nobody can deny that. So fraternity, though the term fraternity has not been explained in the Constitution explicitly, except in one place, that is under fundamental duties. It says common brotherhood transcending the religious, linguistic and other sectional diversity, practices pertaining to sectional others. The term other sectional diversity includes the caste, creed, all these things. So that's very important. So the fraternity is Indian flavor gifted by our Ambedkar, because this is not the class fraternity which is appearing in the French Constitution. Next one is the dignity of individual. In fact, there is a debate in the Constituent Assembly whether the unity and integrity of the country should come first or the individual dignity should come first. For that, they have referred various constitutions. Finally, they have taken it from Irish Constitution. There, the dignity of individual have been put in the first place. So that has been suggested by Ambedkar. So these are the two valuable, important contributions made by Ambedkar in adding or drafting, the strengthening the preamble of the Constitution is concerned. The third key important player or contributor in making of the preamble is in the post-independent country. It has happened, the post-independent history. Who is that? Madam Indira, the former Prime Minister of this country. Through the 42nd Amendment, she added three more terms, that is secularism, socialism and integrity of this country. These are the three aspects which has been shaped or added in our preamble. The first part, largely influenced by objective resolution clause, 2 important terms added by Ambedkar, 3 important terms added by Indira Ma'am through 42nd Amendment. The last but important role played by the judiciary. What is the role of judiciary in strengthening the preamble? Please refer Keshavan and Bharati case that will answer you all these questions. Now we can come back. What is the validity of the preamble of the Constitution? Is it legally binding? The answer is no. Can it be ignored? Answer is no. Can it be amended? Answer is yes, as well as answer is no. How can you say answer is yes as well as no? You can amend the Constitution. You can amend the preamble of the Constitution without affecting the basic structure of the Constitution. What is basic structure? Please refer Keshavan Bharati case. Keshavan Bharati list out certain important terms such as secularism, socialism, right, federalism, all these things as a part and parcel of basic structure. Now you may remember this present government, NDA government, wanted to remove the term secularism by amendment. Can they do that? No, they cannot do, because it violates basic structure, because secularism has been pronounced as part and parcel of basic structure, not only in Keshavan and Bharati case but also in S.R. Bombay case. And whether preamble was a part of the Constitution, once upon a time the Supreme Court has said in Berubari case, no, it was not the part of the Constitution, but subsequently it has been revised in Keshavan and Bharati case. Hereafter it is very firm. Preamble is very much part of the Constitution. You cannot amend the preamble so as to violate the basic structure. So without violating the basic structure, you can amend the Constitution including the preamble. That is what one should remember. Then what is the validity of the preamble? What is the use of preamble when it is not legally binding? One may ask it. So you may remember in evidence, there are certain pieces of evidence that evidence per se is admissible, like direct evidence. Say example, dying declaration. Dying declaration per se is admissible. And solely one person can be convicted solely on the basis of dying declaration. But it is very unsafe. Why? The simple reason is that you cannot cross-examine a person who has already died. So based on his declaration, it may not be feasible, it may not be good to convict a person is concerned. So what is that? You need to have a corroborative evidence. Like that, the preamble per se cannot helpful in protecting your rights, but preamble can be useful in aiding in the interpretation of strengthening your rights. So no one can go to the court that my right has been violated on the basis of guarantee given in the preamble. But the guarantee given in the preamble in any other act or any other provision of the Constitution, then certainly it is enforceable. That is what one should remember it. The best case on this particular point is that BPCL and HPCL case is concerned. Why? Many companies, oil companies, including Indo-Burma Petroleum, Burma Oil Mill, many things have been nationalized by the then Indira Gandhi regime, and she formulated a company called BPCL and HPCL through the parliamentary statute. But later on, the NDA government, one headed by Sri Vajpayee, wanted to privatize this without the consent of the parliament. This is very important. Okay, when the case has come before the Supreme Court of India by a public interest litigation, particularly it is called Center for Public Interest Litigation. Most probably, I think it should be done by Prashant Bhushan, I hope. Please check it out. In this case, Supreme Court answered that Clause 13, Article 39, Clause B is very important bedrock of all our economic activities, and there is no mandate that the government cannot do without consulting the parliament in that particular act is concerned. But they have relied upon the preamble of that particular act which has nationalized the BPCL and HPCL case. Therefore, it said in order to implement the directive contained under Article 39B and C, this particular act has been enacted by the parliament. Therefore, so that has become the very mandate. So so the government cannot go against that particular objectives of that particular act is concerned. So the objectives, there is nothing called an objective clause in that particular act, but by relying upon the preamble of that particular act, yes, the decision taken by the government of India to privatize BPCL and SPCL case has been struck down. So what you may remember, there are two sort of aids for interpreting the Constitution as well as for interpreting the statute. What is that? External aid as well as internal aid. The preamble is coming within a category called internal aid. Okay, so no one can ignore the preamble is concerned. So I hope this program will be very informative. If you have any doubts, please put it in the comments box. I would like to answer you. I would like to thank everyone, those who helped me in this process. God bless you all. Thank you.